Good afternoon. My name is Dr. Sylvan Spooner. It is my pleasure to welcome you to this final lecture of the 2022 lecture series titled Road to Republic, Exploring 400 Years of a Political Experiment. I would first like to thank you, the audience, for taking the time from your busy schedule to attend this lecture series, which has presented a rather comprehensive political and social history of the road to Republican status. It has been a series hosted by the Barbados Museum and Historical Society, the University of the West Indies, Department of History and Philosophy, and the Embassy of Argentina to Barbados. Today's guest lecturer is the Honorable Justice Jefferson Kamabach, who will present a lecture titled Constitutional Reform in Barbados. Justice Kamabach was appointed as a Justice of the Barbados Court of Appeal on January 1st, 2020, after a career as a legal scholar at the University of the West Indies, Capefield campus, where he taught contracts, torts, and employment law in the Faculty of Law at the UWA, Capefield, and served as an adjunct lecturer in sports law in the Faculty of Social Sciences. He is a co-author of the text West Indian Law of Contracts and has published extensively, mainly in contracts and employment law in some of the leading regional and international law journals. He drafted the Consumer Guarantees Act 2002 of Barbados and has undertaken legal consultancies on different aspects of the law for various foreign, regional, and local institutions. From 2009 to 2012, he served as a member of the Regional Judicial and Legal Services Commission. In addition, he served from 2008 to 2018 as chairman of the Anti-Money Laundering Authority and as chairman of the Fair Trading Commission from 2015 to 2018. In November 2010, he acted as a Justice of Appeal of the Eastern Caribbean Court of Appeal. I have no doubt that there will be quite a number of questions for Justice Kamabach due to the topical nature of this lecture. So I ask that you put your questions in the Q&A section on Zoom or in the comment section on Facebook. I now have the pleasure of introducing Justice Kamabach to present his lecture, again titled Constitutional Reform in Barbados. Justice Kamabach, the floor is yours. Justice Kamabach. I think he may be muted.
Yeah, I was unmuted. I was muted.
Yes, the floor is yours.
Thanks for the introduction, Dr. Spencer, and thanks to the Barbados Museum and Historical Society for inviting me to give this lecture. Unfortunately, and it is bad form, I admit, I must start with a few caveats or exemptions. The sensitive nature of my day job and its code of ethics require that I do not tread on matters of pure state policy. For example, on the issue of whether a popular referendum should have been instituted before we became a formal republic. That is a political matter, and I'm not allowed to comment from the bench on those. Equally, I cannot speak to any matters, even those of a constitutional import, that are currently or likely to become sub judice, more so when the matter is before the Court of Appeal and when I am a member of the panel designated to hear that appeal. Such matters include the constitutional composition of the Senate, arising from the claim filed by the former Attorney General against the present Attorney General and the state, and the constitutionality of the proposed prohibition of the release on bail where an accused is charged with certain firearm offenses. That's before us at the moment, and I will not be able to comment on that. Equally taboo will be the litigation arising from the disenfranchisement in the January 2022 elections, where those who were institutionalized because of COVID were not able to vote. That is also before the Court of Appeal at present. These considerations having been placed before you, I now propose to discuss my topic of constitutional reform in Barbados. I do hope you will find it engaging. We can agree that this is the most exciting time for the issue of local constitutional reform. The recent establishment of the Constitutional Reform Commission affords each of us the democratic right to become a founding father of the new Barbados Republican Constitution. When decades from now, interpreters seek to ascertain the meaning of a provision in that document, and they have recourse to the intention of the founding fathers, it will be to us that they will be referring. And this is quite a contrast from the 1966 Independent Constitution, which was merely a schedule to the Barbados Independence Order. We played no role at all in deciding what the text of that document should be. Now we are able to play a role in what the constitutional Republican, the Republican Constitution should look like. One reservation that I have here is that there might be a general public ignorance of precisely what is contained in the current constitutional text. This need not detain us much, however. Democracy thrives that everyone should have a say, whether you know or you have read up on the issue or not. So what I said here is that this need not detain us. The ignorance of the precise issue is seemingly an indispensable aspect of democratic decision, but the democratic choice is not reserved for only those who are able to pass a qualifying test to establish familiarity with the issue which is being discussed. So the fact that you might not know what the present constitution says does not debar you from making a suggestion as to what the Republican Constitution should say. You may have noted that earlier I referred to Barbados becoming a formal republic. I did. The use of the adjective was intentional. I am one of those who consider that we were already a republic in substance, and that our retention of a foreign monarch as head of state served only to create complexity in defining ourselves constitutionally. My thesis, and you might not agree with me, feel free to do so, is that we were, even before November 30th, 2021, a democratic republic with a foreign monarch as the constitutionally nominated head of state. In my view, this did not thereby necessarily create us as a monarchy, no more than we would have been a sultanate had we nominated the Sultan of Borneo as our head of state in achieving independence in 1966. So I hope you understand what I'm saying there. My view is that we were always a republic, even though not by name. We were, some call us a constitutional monarchy, but I have a difficulty with that. We were not a monarchy in this. We had a foreign monarch who was a queen, the Queen of England, but she was not our choice necessarily as a people. She didn't come from among us. But that does not concern us now. We are past that stage, and we now have our own native head of state with whom we are well pleased. The Constitution itself I'll look at now. In an article published in the West Indian Law Journal for 2012, my erstwhile faculty colleague, the late Professor Simeon McIntosh, partly rightly in my view, posited that, and I quote, unlike the British Constitution, which is not contained in a single discrete written political text, the West Indian Constitution, including Barbados's, clearly stands in the tradition of written constitutionalism. The idea of a discrete political text constituting the polity, structured on the principle of separation of powers, in particular establishing an independent judiciary institutionally separate from the legislative and executive orders of the state, and entrenching a set of basic human, civil, and political rights of the citizenry that are judicially interpreted and enforced in favor of the citizen against the state and its various organs. And to me, I said he was partly right in that, because we have a written constitution, and we'll continue to have a written constitution. We do have a discrete political text constituting the polity, and we do have all the other features in which he pointed out. The independent judiciary, which is separated from the legislative and executive orders of the state in some respects, and entrenching a set of basic human and civil political rights of the second citizenry that are judicially interpreted and enforced in favor of the citizen against the state and its various organs. And it is my opinion that whatever detailed form or attempts at constitutional reform in future might take, we should retain this existing structure in the new republic. That is, that we should have judiciary that is separate from the legislative and executive organs, and that there should be a section of fundamental rights to which we all aspire and ascribe. Finally, I want to state that the views I advance here are for the sole purpose of considered discussion among yourselves and should in no way be thought of as binding notions. Indeed, and in an exercise of democratic reform, no one view supersedes another, although we must accept that no one will get all that he or she wants in a negotiation, a democratic negotiation. And this is a negotiation because this process of reform is to be regarded as a negotiation or bargaining phenomenon, where views will be advanced for consideration of first the Constitutional Review Commission, and then, if recommended for inclusion in the document, the consideration of its best expression by the drafters of the final instrument. That's where we'll be progressing. The constraints of time will, of course, not permit a comprehensive discussion this afternoon of what the reformed Republican Constitution may look like, but we can discuss the superstructure as delineated above by McIntosh. This will include the fundamental rights, the legislature, including the mode of and composition and provision for likely future complexity in election outcomes, the executive and the judiciary. First, the final fundamental rights. Should we choose to adopt the McIntosh constitutional structure referenced above, our first task is to identify the catalog of basic human, civil, and political rights to which the person should be entitled to which the person should be entitled, and to have protected against the legislative, executive, and administrative acts of the states and its several agencies. Protection from inhuman treatment is one, certainly the right to freedom of expression. And Chapter 3 of our existing supreme law, to which I refer you, have already conferred or already confers a number of such rights and freedom, none of which I imagine we will be prepared to surrender in the new republic. I refer to the right to life, the right to personal liberty, freedom from slavery and forced labor, protection from inhuman treatment, protection from deprivation of property, protection against arbitrary search and entry, the right to the protection of the law, freedom of conscience, which would include the freedom of religious belief, freedom of expression, freedom of assembly and association, and freedom of movement. Section 24 of the said Constitution provides that if any of these rights has been or is being or is likely to be contravened in respect of the person by state action, that you have a right to apply to the High Court for relief. Apart from these, the Commonwealth Caribbean Court of Justice has held that the rights eliminated in the preamble of Section 11 are also enforceable. And these include, although they are repetitious in some ways, include the right to life, liberty, and security of the person, protection for the privacy of one's home and other property, and from deprivation of property without compensation, the protection of the law, and freedom of conscience, expression, and of assembly and association. The issues of reform that confront us here are whether we should claim additional fundamental rights, and if so, which ones? Should they be, second, should they be enforceable against state action only or against anyone? And should they remain subject to Section 26, the saving law clause that immunizes pre-1966 laws from being held to be contravention a contravention of any of the fundamental rights or freedoms. I'll explain these developments further when I come to them. So far as additional rights are concerned, the suggestion has been offered that these should be in the nature of what are called the ECOSOC rights, ECOSOC, which is short for economic, social, and cultural rights. These would include the right to adequate food, to adequate housing, to education, to healthcare, to social security, and to water and sanitation, and to the right to work, which some people believe already exists, but it doesn't really it's not an express right in the Constitution. But some people have suggested that these ECOSOC rights, and a very good example of the integration of these rights into a constitution can be found in the 1996 South African Constitution, where most of these ECOSOC rights are fundamental rights of the person in South Africa. The difficulty you might have is that these rights have variable standards of compliance, and therefore you will need to spell out very carefully precisely what the right entitles you to. Another right which might raise some complexity in Barbadian discussion is one which has been identified in some recent pieces of legislation, and that is the right to sexual orientation. When it was advanced to the Ford Commission back in the 80s, the Ford Commission did not feel that there was enough support for it to recommend it. But now, given the recent legislation such as the sexual discrimination, the Employment Sexual Discrimination Act, and the I forget what it's called. It's the one where you can work in Barbados for 1 year. That law, all those laws protect sexual orientation in some way or another, and to have it as a fundamental right it might be the time is right for it now. As I said, I'm not offering an opinion on it, but I am suggesting that it could arise for future discussion. The Saving Laws Clause, where referred to as Section 26, is another interesting aspect of the discussion of when you're looking at the fundamental rights. And Section 26 serves to immunize pre-1966 laws in the Independence Constitution from being held to be a contravention of any of the fundamental rights or freedoms. The CCJ has not found favor with the CCJ, and in a majority judgment in a case called Nerve and the Queen, this was the view of the majority in that judgment. It was a 4-1 decision. Justice Anderson dissented, well, not dissented from the final result, but he dissented on this point because he thought that Section 26 should still apply but be limited in other ways. But the majority was of the view that the idea that a provision of inconsistent with a fundamental right, a court is because of a provision which is inconsistent with a fundamental right, the court is prevented from declaring my print here is not correct, of that inconsistency, that because the laws form part of the inherited law from the colonial, it must be condemned. They are saying that because it form part of the idea that it binds judges now because it was passed before 1966 and that they can't interfere with it, that must be condemned. And they quoted the same McIntosh who I quoted earlier for defining the Constitution. And they said, the horror of this is what McIntosh said, quote, "The horror of this is brought home to the intelligent mind when one realizes that the literal consequence is to give prominence to ordinary legislation over the Constitution." And well, we wouldn't have to worry about keeping 26 anymore, not in the text, certainly given the attitude to it of the Caribbean Court of Justice. And the Caribbean Court of Justice would forever said it would forever frustrate the basic independence provisions that the Constitution of the supreme law is the supreme law, and that the judiciary is independent. So the Section 26, as the Savings Law Clause, will not be a bother to us anymore. That's all I want to say on the fundamental rights provisions. I leave the rest up to you, and perhaps in discussion, you can advance some fundamental rights that you would like to have included or would want included in the Republican Constitution. This bears out the point that we are the founding fathers of this Constitution. Well, the founding fathers we would be, because unlike, say, the United States, or where a group of men get together and form the Constitution, we are opening it to democratic consideration. So your view is as important as mine. Mine doesn't hold any more weight because I'm a justice of appeal. Yours as a citizen would count for as much. Having looked at the fundamental rights briefly, we can now look at the legislature. And why it is important to consider all possibilities is that if we look at the last few years of this political discussion, the 30-love result, looking at the two major parties in 2018 and 2022, was definitely not foreseen by the founding fathers or the creators of the 1966 Constitution. They all thought that there would always be an opposition and that there would be someone to be leader of the opposition. When that did not occur, then it threw us into a tailspin. So now we can provide in the Republican Constitution precisely what should happen if such an event should recur. And this is an important aspect of drafting, that you have to look out for possibilities that might seem absurd or remote and cover them. And had they looked out in 1966 for what should happen where there's a result such as the one in 2018 or in 2022, well, then we would have been covered, because we would have had a ready-made provision to cover such eventualities. In this regard, there's another eventuality I think that could cause some confusion, and which is not expressly provided for in the Constitution. And because our lower house comprises 30 elected representatives, a 15-15 result between two parties is eminently possible. What should happen in that? That's also could cause a complex state of affairs, a conundrum, and we should at this stage look out and suggest what should happen in such an eventuality as well. We would have been foreseeing the probability and therefore dealing with it at this stage, so that if it should occur, we would have had a ready-made provision to cover it. Another area we can look at here in terms of Parliament, the parliamentary order, is elections. And there's been the view advanced. I don't want to comment particularly on it and give you my view. As I said, my view doesn't matter any more than yours. But this is whether this should not be, rather than first past the post, whether there should not be proportional representation. That has its pluses and its minuses, I suppose, its pros and its cons, and we can discuss that in the question section as well. The question of recall of a member of parliament has also been brought, and so too has been the question of fixed date elections every 5 years or 4 years, whichever we settle on. And so too has been limited terms for the Prime Minister, if that should come to that. I'm wary of treading on that kind of ground. As I said, my remit does not include comments on policy. So you will report your views on that to me, and I can discuss them with you. The executive, which is the final aspect of the matter, they have the fundamental rights, you have parliament, you have the executive, and you have the judiciary. I'll come to the judiciary last of all. The executive is now, the question arises, how should the president be appointed? Or how should he or she be selected? The present position is that they're nominated by the lower house, and then there's a vote on the nominee, and that person then becomes the president of the Republic of Barbados. Do we want to change that in any way? You let me know what your views on it are, and I'll tell you if it's legally possible or if any legal implications will be raised thereby. Question also the executive is whether the cabinet members should be subject to parliamentary approval or whether you're satisfied with their nomination by the Prime Minister. So far as the judiciary is concerned, the important aspect of the judiciary is that the judiciary should remain independent of both the other two organs of state, the other two powers of state. And as the text of the Constitution stands, there's not that separation in hard terms, because the judiciary is now could be selected by the political authorities, the executive. That's not the practice in Barbados now. However, I know that since 2020 at least, certainly with my election and the election of those who were appointed with me for the Court of Appeal, the matter of the appointment of the judiciary was delegated to a body appointed, well, a body, an independent body who scheduled interviews and read your CVs and your backgrounds, and then chose the judges of Barbados. Do we want that to continue, or should we stick with what exists at present? In any case, in my view, independence is a personal thing. You could remain as independent as you wish. No one can force you to be, or if you don't want to be. So that's pretty much up to the judges themselves. But an independent judiciary is necessary for working democracy, I would think. And so we will want to ensure that the provisions are in the Constitution that guarantee the independence of the judiciary. Does anyone have any questions for me at this stage? Dr. Spooner?
Yes, not as yet. I guess as you complete your lecture, there'll be a few questions at that point in time, but you're free to continue.
Well, I don't have much else to say, that's the truth. I've already covered the fundamental. I know I was doing it very quickly, but I trust that people could hear me and understand what I was saying. I could recap briefly though, so that we could engender some questions. I first dealt with the fundamental rights, and I look at the ones which exist currently, and I suggested that we would not want to remove them or to surrender them at this stage where we are doing a new Republican Constitution. We might want to include some of the economic, social, and cultural rights, and I delineated some of them. I referred you on to the South African Constitution, where you can see the text of some of these eco rights guaranteed to citizens and other persons. And then I said that we had to look at the fundamental rights in terms of whether they should be enforceable against the state. I don't think I covered that completely. Whether it should be enforceable against state action only. There's something in law called the state action doctrine, which says that if you're saying that there was a contravention of your constitutional right, such an action can only be had against the state or one of its organs. It's not, if you can't have a constitutional action against an individual entity or a person in the form of a company. And we had a case in Barbados many years ago now, where some workers were complaining that their fundamental right to freedom of association was breached because they were dismissed when they attempted to unionize. And the court held that that was not a proper method of recourse. They could not sue the employer for a breach of constitutional rights. So what happens now in Barbados is that while public servants can sue for an employer for breach of constitutional rights because their employer happens to be government, the ordinary worker cannot. The ordinary worker must seek his or her remedy in employment law, while the public worker may be able to have an action in constitutional law, provided you could make out a contravention of that law. That in brief is the state action doctrine. What I am throwing out for your suggestion or for your consideration is whether we should have a strict following of the state action doctrine, or whether the action for infringement of your constitutional rights should not be available against a citizen. We don't have this, and we are not in that type of that variety in the Caribbean. I know in the United States, you have probably heard of the contravention of civil rights. It would be an action like that that I'm contemplating, where if you can show your fundamental rights are infringed by anyone, even though they are not a state or a statal organ, that you could still be able to maintain an action for contravention of that right. Then we look at the question of the Savings Law Clause. I told you that the CCJ, our highest court, the Caribbean Court of Justice, had poo-pooed the significance of in my view, the significance of the Savings Law Clause in Nervée and the Queen, and that they had adopted the reasoning that it would be contrary to the idea of independence if you could bring laws pre-1966 to challenge or to overpower laws, the fundamental rights which we adopted on independence. And as I said, the CCJ, who said it would forever frustrate the basic on the land principles that the Constitution is the supreme law and that the judiciary is independent. Finally, I offered some suggestions on the Parliament and the executive and the judiciary. I asked in Parliament, we can have a 15-15 possibility. Should we make provision for that now, and not, given the results of the last two general elections, whether we should not now provide for what should happen in the event there is such a result? And I looked at the executive. What should we do about the selection of the president? Whether the public should have a greater role in that or not. I've thrown that out for your consideration. And the judiciary, which I suggested should always remain independent, although that's a personal attribute, whether we should make provision for how the independence of the judiciary by providing specifically for how they should be appointed, different to how it is in the Constitution. I'm ready to take questions now.
Okay. Thank you very much, Justice Kamabach, for your erudite presentation on constitutional reform in Barbados. First question we have for you. This question is all law constitutional law? Again, is all law constitutional law?
No, not all law is constitutional law. Well, if you had heard my CV, you had heard that I taught contracts and employment law and sports law. Law is of different kinds. Law is law, but not all law is constitutional law. Law has the effect. If it is a principle of contract law, it says that you must follow it if you're doing contracts, and it would apply to that. Constitutional law applies to the relationship between the citizen and the state at one level. There's also administrative law. It's part of public law. That is the law regulating the arrangement between the citizen and the state. But the constitutional law has a special quality to it, in that the constitutional law is the supreme law of the land, and law must conform with the Constitution if it is to be held validly to be valid law. But all law is not constitutional law.
Thank you very much, Justice Kamabach. Another question here for you. Does practice, for example, labor practice, work like law, or does it fall short of actual legal enforcement and/or recourse? Again, does practice, for example, labor practice, work like law, or does it fall short of actual legal enforcement and/or recourse?
Labor practice, well, if you're trying to separate it from practice from what the law is, then the question answers itself. But I would think that some practice has become formed into law at most levels. And if that practice is consistent with the law, then your question answers itself as well.
Thank you.
I suspect there'll be a follow-up on that one.
Another question for you, Justice Kamabach. Does common practice ensure fundamental rights under the law? Does common practice ensure fundamental rights under the law?
I have a difficulty. I don't know what common practice means in that sense.
Hopefully, I can get a clarification for that question for you, but we'll proceed to the other question. And this is, has there been any social influences or occurrences which have impacted the shape and form of our Constitution as time has passed? Has there been any social influences or occurrences which have impacted the shape and form of our Constitution as time has passed?
I'm trying to think of whether there has been any. I would imagine that the shape of the Constitution, yes, there has been. I recall there was an amendment to the Constitution when the two senators, at 2018, when two senators had not yet satisfied the criteria for becoming senators. I think it was the residence requirement, and two other senators were allowed to take their place until they had become qualified, until they did become qualified. So that would be an incident which affected our Constitution in that sense.
Thank you very much. I have another question here from the Reverend Badilaria. And it says, please accept my apology if the matter of political parties being represented in the House of Assembly has been addressed. If it has not,
the Constitution that we are on that still doesn't speak to political parties.
This has a continuation here. If it has not, will the new Constitution allow for persons to vote for a party of their choice? That is from
What
the
the
record.
new constitution will do is what we want it to do. That's the point I was making in my speech, that we are the founding fathers of the new constitution. And if you want something in the new constitution, you should go to or write to the commission, the Constitutional Reform Commission, and put it in their minds that you're interested in this new proposition. As I said, I think I can quote back from my lecture. If the commission finds it that is something that they could put forward if recommended for inclusion in the new constitution, in the document, the consideration of its best expression by the drafters. Once you put it forward to them and it is acceptable, something that they want, that they think should go forward. I'm not so sure how much discretion the Constitutional Review Commission has with certain proposals, but they must have some, because that's why the commission was formed. It's not that they'll accept every recommendation from everyone. It's what they, in their deliberations, would consider worthy of inclusion in the new document. And if Mr. Larrier's point is well put, is cogently put to them and convinces them, well, then they will put it to the drafters that parties should be included in the new document. So to answer a question as to whether the new document will include it or not, that depends on Mr. Larrier himself, not on some theoretical underpinning, as it were.
Thank you very much, Justice Kamabach. That seems to be the end of the submitted question section. So I'm going to open question now to Ms. Hall. I don't know if Ms. Hall has anything that she would like to ask. Ms. Hall?
Or you yourself, Dr. Spooner?
I actually do not. It was actually a quite interesting lecture. I do not claim to know quite to know a lot about the law. So it was interesting to learn sort of how these things work. I, for example, hadn't really thought about the idea that we are pretty much craftsmen of our fate here with regard to the creation of this new constitution. So it was good to look at it from that perspective. So I would have to thank the Reverend Larrier for sort of putting us in that direction and really making us sort of spell that one out. But I actually did perk up a bit when the other question was asked as well about any social influences which might have affected the way how our constitution did, because I actually automatically thought of things like the 1937 riots and so on, if they, for example, had any impact on what constitutions were like in Barbados. But I don't know if Jeff wants to speak to that.
Yeah, I do, but we can have a constitution until the English gave us one in 1966. That's the truth. It would have influenced the law, though. Well, I don't know at that time. It did influence the law. The Moyne Commission came in and set up, and labor unions were legalized, because before they were viewed as restraints on trade, that they were formed for the purpose of improving salaries, and that was not a lawful combination. The combination acts made workers' unions unlawful. So the Moyne Commission, which was a consequence of the 1937, whereas if you call that a constitutional law, the legality of the workers' unions, then that did have an effect on our constitution, quote unquote.
Oh, so then, like, for example, something like when we had the 8% cut, and then we marched again, and then later on, a succeeding government comes in and makes it illegal then to cut salaries without.
And it was a constitutional measure as well. So you're right on that too. Yes.
Okay. I'm learning. So basically, social action can in fact influence the constitution.
Yes, it can. Something that you change willy-nilly. So not every social action will influence it. But if it's a groundbreaking move or a earthquake, a shattering social event, then it is likely to influence what your constitution says.
Would it be asking you to step out of your comfort zone then to ask about public opinion with regard to things like our laws on things like same-sex marriages or the recognition of, I don't want to put you on the spot, because I know that right now our laws are a bit, in some cases, antiquated with regards to things like that when compared with what may be happening elsewhere in the world.
Yeah, but as I just told Dr. Spooner to the question from Reverend Laria, we are the framers of the Constitution, so we will have the right to sexual orientation in our Constitution as a fundamental right if we want it to be, or if it is ordered on us. But we will be, if we say we don't want it, or we say so in a sufficiently cogent, loud voice, well, then it will not be included. But we are the architects or the founding fathers, as I call us, of our new Constitution. We will determine what goes into it and what doesn't. So things like the eco-salt rights that I talk about, I think they might get in. Well, provided the knowledge is there, that when people know what they are and how they can be drafted and how they can be included in a constitution. So our fundamental rights will, I imagine, under the Republican Constitution, look a lot different from what it looks like now, or different, whether a lot or not, but different from what it looks like now. And that will only come through our advocacy.
I actually remember there was quite a bit of a toss-up right around the time when we became the Republic, when some people objected to the taking out of the word God and replacing it with a sovereign being. And there was quite a bit of a fuss then. So I can see we probably got quite a bit of arguing ahead of us.
Yeah, we do. These are very interesting times in the Chinese sense of that word.
I think I kind of look forward to it. I have not enjoyed living in history in the making with regard to the COVID pandemic, but I think I will enjoy being a part of history in the making when we hammer out our new constitution. I think that is it for me.
In 100 years from now, if our Republican Constitution still survives, when people are talking about what was intended by the founding fathers, it'll be us they were talking about. Did we intend that this clause should be interpreted in this way or not? Do we intend, as they asked with the Americans, did the founding fathers intend that the right to bear arms should be a collective right, or should it be an individual right? And can you bear arms by exposing them, or do you mean keep them in your home? What is intended? So we have a warning to be clear in what we want. Just as I said with the 13 love, we didn't make provision for that because no one contemplated it. But now 1550 is a possibility. And what will happen then, we are unsure. So we can now make provision for that, for probability or possibility, foreseeable probability.
It is going to be very interesting. One of our preceding lecturers, I think about 2 weeks ago, put forward the idea that while it is possible to have a 30-love majority, what you could in fact do is then divide up the representation in the House according to the numbers represented in the popular vote. So while you may have lost all the seats, you may still have gotten 30% of the popular vote, and therefore you should have 30% representation in the House, which I found to be a quite interesting idea at the time because it had never occurred to me. And it is, I believe, similar to the American system to a certain extent, I'm not sure, but it does give you food for thought.
Yeah, what they're throwing out is proportional representation, which is you vote for a slate of candidates instead of a candidate. Mm-hmm. So if you get 30% of the votes, you would be entitled to 30% of the seats in the House, which would be 9 seats, I think.
Something like that, something like that.
Yeah, and I did throw that as a suggestion too. I don't want to comment on it. That's a matter of policy for the policymakers to do, not for the judges.
Understood, understood. I think that is it for me with regards to questions and follow-up.
You have any, Dr. Spooner?
No, I don't at this point in time.
Okay.
See if they have any other questions. that seems to be the end of our question and answer segment. I don't see anything else being asked here. So we've come to the end of our Q&A section. So once again, I wish to thank Justice Kamabach for a very topical presentation on constitutional reform in Barbados. I would also like to thank all those guests who presented throughout this now concluded lecture series, and of course, our viewing and listening audience for their thoughtful engagement. Gratitude also extends to our partners and sponsors, the Barbados Museum and Historical Society, the University of the West Indies Department of History and Philosophy, and the Embassy of Argentina to Barbados. So that brings an end to this. Yes.
I thought you were finished. Thank you for chairing this session, and thank you, Ms. Hall, for inviting me. I appreciated it very much.
You're most welcome.
All right, thank you. Goodbye.
So that brings an end to this evening's, and by extension, the 2022 lecture series. To all, a safe evening. Thank you.
A safe evening to you too. Good evening.
Good evening to you.